Hi. Today in this video, we will see in a nutshell how this insolvency resolution process works. As I had mentioned, it is called corporate insolvency resolution process, which can be initiated against a company or an LLP by a financial creditor or an operational creditor. Financial creditor is a person who owes financial debt to the company, which includes banks, financial institutions, etc., and home buyers. Operational creditors are, in simple terms, are called suppliers of goods or service providers. So if this company is not making their dues, the payment towards these operational creditors or financial creditors, they can file an application before the adjudicating authority in specified forms. If it is a financial creditor, they can file an application either singly or jointly with other financial creditors. There is a prescribed fee and prescribed form for the filing this application. And once the financial creditor decides to move the application, they can submit the application along with the petition before the adjudicating authority, along with the record of default and other relevant documents to prove the existence of a debt. Wherein, in case of an operational creditor, the supplier of the goods or service provider against whom the debt is defaulted cannot directly move their application to the adjudicating authority. They have to first issue a demand notice to the corporate debtor, and corporate debtor within 10 days of the receipt of the demand notice can do two things. One is that they can state that there is a pre-existing dispute due to which we are unable to pay your money. Second is that without any demur or protest, they can meet their commitment or make the payment to them. So if the operational creditor is not getting the intimation from the CD with regard to the pre-existence of the debt, or they are not getting the payment against a particular demand notice, they can now file the application before the adjudicating authority. So adjudicating authority, on receipt of these applications, which is in the form of a petition, will adjudicate on the matter, will issue notices to the opposite side, hear both sides, and pass the orders. Though the code is specifically mentioning that it should be passed within 14 days, considering the current infrastructure of the Indian judiciary, that is not actually in reality not happening. But even then, it is actually having the pace larger or higher than other kind of litigations. So, in nutshell, when a matter is being placed before the adjudicating authority will review the records, and if it is proved that there is a debt which is defaulted and there is no pre-existing dispute with respect to the operational debt, they will admit the application. Once an application is admitted, that is the date of commencement of the corporate insolvency resolution process. CIRP is basically, as the name suggests, is a resolution process on which the time period will be observed. 180 days time period is there, within which the resolution professional who is appointed by the adjudicating authority will try to resolve it through a specified method. So once an public announcement is, once an application is admitted, the resolution professional will actually step into the shoes of the promoters of the company or board of directors. So technically, board of directors will lose its power and will not be in that particular position, and RP will supersede them and will come into the charge of the company. So, responsibility of the resolution professional is to operate this corporate debtor or a company as a going concern. Unlike the previous regime, suppose under the SARFAESI Act, when an insolvency process starts or SARFAESI proceeding starts, the company's activities is coming to a standstill. But in case of an IBC, the resolution professional, who is a qualified professional, is mandated to operate the company on a going concern basis. That means business activities will be continued, companies, all the commitments will be met, all the performances will be happening, all those things will be under the supervision of the resolution professional. So within first 30 days time period is for the RP to make a public announcement, collect the claims based on that public announcement from all the creditors to whom this company have to pay money, and collate that claim and constitute a committee which consisting basically of the financial creditors. That committee is called a committee of creditors. Once a committee is formed, that committee is going to be actually working together with the RP. to identify a resolution for the corporate debtor. The rationale behind only financial creditors in the committee is that in a particular judgment of Cis Burns, Honorable Supreme Court of India had specifically that identified an intelligible differentia between financial creditors and operational creditors and said that financial creditors are more interested in the revival of the company than the operational creditors, and hence it is logically correct to put them only into the committee. So this committee, along with the RP, will continue the process. On 30th day of the commencement, this committee will be constituted, and this committee can either continue with the interim resolution professional who is appointed by the adjudicating authority, or can appoint a new resolution professional by replacing the interim resolution professional. So this interim resolution professional will be replaced by the RP or will continue as the RP, who is having a huge list of duties to be performed within next 180 days. He will conduct a forensic study. He will do a valuation of the company with the help of registered valuers, and he will invite the interested parties to submit their bid to take over this company. That process is called resolution process or submission of resolution plans, invitation to submit the resolution plans. So once the expression of interest is published by the RP under the supervision of the Committee of Creditors, and valuation and forensic audit, everything is on place, the interested party who wants to take over this company as a going concern can submit their bids. That bids is called resolution plans. There are stringent norms which is governing the submission process of the resolution plans, contents of the resolution plans, mandatory requirements to be included in the resolution plans. So it is the responsibility of the resolution professional to ensure that the plan is in accordance with the provisions of the law. If the plan is submitted before the RP will have to see whether the plan contains all the mandatory provisions mentioned under section 30 of the IBC, and if everything is perfect, he will place it before the Committee of Creditors. If there are multiple plans, he will submit those plans after verifying these things. Once it is placed before the Committee of Creditors will evaluate it from the commercial angle of it, and the committee will decide how to approve that plan. Based on a competitive bidding or based on a evaluation metrics, this plan will be approved. Once the plan is approved, then it has to be placed before the adjudicating authority for its final approval, which is actually based on its own satisfaction. So while approving this resolution plan by the Committee of Creditors, they will look into how the debts of this corporate debtor can be resolved. There is a waterfall mechanism which is mentioned under the IBC under section 53, which is not mandatorily required to be followed at this stage. The Committee of Creditors will see that all the creditors, because as I had mentioned the preamble itself, there is a requirement of balancing the interest of the stakeholders. So as provided under the IBC under section 30, the Committee of Creditors will evaluate the commercial side of it, RP will evaluate the legal side of it, and place it before the adjudicating authority along with its approval. Adjudicating authority will review all these things based on certain declarations given by the RP and certifications given by the RP, will approve the plan. Once a plan is approved, that will be binding on all the persons, including central government and state government. Suppose in case a resolution plan is not coming, or the plan which is being submitted before the committee or RP is not meeting the mandatory requirements, or the bidder is failing to convince the commercial aspect before the Committee of Creditors, this plan will get rejected. Or even with the approval of the RP and COC, it is being placed before the adjudicating authority, and adjudicating is authority is rejecting this plan. In that case, there is no plan in hand. In that case, there is no other option other than to send this corporate debtor into liquidation by the adjudicating authority. So in nutshell, if a resolution plan is there which is approved by all the RP, COC and adjudicating authority, the company's chance of getting revived is higher. In the absence of a plan, the company have to go into liquidation. So liquidation is a different topic which we need to discuss in detail in later videos, and we will see that in detail. So thank you very much for the patient listening.